pleasure to be here. Good morning, Shamim and Tracy, and good morning to the listeners.
I want us to begin from the point of the judge clarifying that the international warrant of arrest is non-existent, but certainly we know it's what the lawyers asked for from court. Not to criticize whether they could have been aloof of what the situation was, but we want to understand from you what then is the current warrant of arrest issued and written to the Interpol? What should it be referred to as?
Well, it's true, and indeed it was right for court to clarify, because there's nothing as an international warrant of arrest, at least under Ugandan laws. Ugandan courts cannot issue an international warrant of arrest. A warrant of arrest ordinarily is a document which is ordering any authority to arrest someone either and to bring them to court. It can be issued when someone's either a convict or whether there's a court order, or when for purposes of bringing that person before court, like in this case for Isaac, where a criminal case was instituted against him, criminal summons were issued, and he has not appeared in court, and the prosecutors, who are private prosecutors, the two lawyers, asked for an international warrant of arrest. It should be noted that court had earlier issued a warrant of arrest, and Ugandan courts can issue a warrant of arrest for ordering any police officer to arrest that person and bring them before the court which issued. What I think caused some bit of confusion was that, well, the lawyers prayed for an international warrant of arrest, and court said that let it be issued to Interpol. And of course, it's important to clarify some facts. Interpol is not an arresting authority. Interpol is a coordinating agency. In fact, countries become member states voluntarily. I think right now it has about 184 members. And Interpol doesn't execute warrants. Now, if there is a warrant issued by a local authority, like a court issues a warrant of arrest, and it's served onto Interpol, Interpol goes through some bit of processing, because Interpol is governed by a constitution. It has rules, and then it issues, if it deems it right that this is a case, one that it was issued by a lawful authority, like for instance a court, and that indeed it doesn't go against the set rules of Interpol, then Interpol issues what they call a red notice. It's an alert to its member states that if you see this person, you may arrest them. So Interpol does not execute a warrant. It doesn't have a force which is self-executing of the warrant. So when it issues that alert, those countries where the person may be, and it's discretionary, may choose, because it also depends on the different laws of the country. The country may have laws that for us, we don't arrest people who are wanted of such and such crimes. So the country, if the red notice is issued, the country chooses whether to arrest that person. But even when they arrest them, they go through some bit of a process, extradition process, where the person will be taken through that country's courts, and he or she is given a chance to be heard whether he should be extradited or not. Now, what they call an international warrant of arrest could only be issued by maybe an international criminal court, like the ones we have against Konyi, against President Bashir, and so on and so forth. Those can only be issued by a court which has international jurisdiction. Clearly, the Uganda Road Chief Magistrates Court doesn't. So there are several processes, and that's why maybe the lawyers thought that when an arrest warrant is issued, it's self-execution around the world. But there are processes. Because like I said, even for Interpol to issue a red notice, it first has to go through a process. And I don't think that Isaac's case is one which may require a red notice.
Counsel, let me just jump in right there. How does this shift the dynamics then for already the court battles that he has?
Of course, there are a number of them. And just to set the facts right, some people I've seen on social media were confusing this case with the one of Justice Sekana's judgment. This is totally different. This is a criminal case where he has not yet appeared, he has not yet taken plea, so he's not a convict in this one. I know that he has challenged the proceedings in the Uganda Chief Magistrates Court before the High Court, and I know that he has sought to stay the proceedings. To the best of my knowledge, I think it has not been heard, neither has it hasn't been fixed for hearing. And of course, which is also some bit of indictment on the judiciary, because we're talking about the president of Uganda Law Society, and I'm not saying that laws should be treated discriminatively or people should be treated, but we've seen instances, even in criminal sessions. You know that right now the criminal trial Mole Katanga and others is ongoing, which happened 2 years ago. There are people who have been in prison for years before facing trial. So sometimes judiciary expedites some cases depending on the nature. And I would think that a case involving a president of the Law Society should be one of those which should be heard. If they are to dismiss, let them dismiss, such that we know, or if they are to hear it. So, of course, I also know that there is no order staying the proceedings at Uganda Road. So the Chief Magistrate is not barred from going on with the hearing until there is a stay. The bigger issue should be, why shouldn't the High Court hear that matter and we have a decision either to dismiss or to stay the proceedings, because it's just a continuation of the battles. And of course this warrant may not change so much. It goes to, I think it's not yet here, and I know that it's not going to be executed anytime soon, so it may not affect so much. The bigger issue should be that the High Court should hear that the case here set before them, and then to see whether the proceedings are right or not.
What are the president's options? I mean, the president of the Uganda Law Society should be having options to his disposal. What are some of those?
Of course, the first option is what he has already taken, challenging those proceedings before the Uganda Chief Magistrates Court. And like I've mentioned, it's pending hearing. And if it's hard and determined, then it will give him a way forward. It could be in his favor, it could be against him, and still he has a chance of appeal. But even with this warrant, which they purported to call international or not, even if it's served on to Interpol, there are processes that have to be gone through for Interpol to make any decision on the warrant. And like I mentioned, Interpol has rules which prohibit it from issuing red notices in some cases. My opinion is that this is one of those cases, because, for instance, if cases are, it's a political witch hunt, if they go against the human rights, if they are moral in nature or about cultural norms, that the offense which is being charged with originally, it's in the penal code, a very old offense. There are people who may think that maybe what he says should be construed with in the 1995 Constitution, but that is a debate for the Constitutional Court, because I know that he has also challenged those very provisions in the Constitutional Court. So he has a number of options. The only challenge is, will the system work in tandem with him? Because if you file cases and they're not heard, yet the motion is moving against you, then the question is, will it move in time to save him?
Then there are questions of fairness in the hearing, or fairness to the justice.